Thanks for having me, and it's my pleasure to be here today. And what I'm going to be focusing on is talking to you about your legal rights and employer obligations when dealing with individuals who have suffered and experienced brain injuries. And so I'm going to share my a PowerPoint presentation just as a guideline if I can, and bear with me for a moment as I see if I can do this. Can everybody see this?
Yeah, it's working, Tom.
It's working, but let me see if I can be able to go backwards. Okay, perfect. Look at that. Okay. So what I want to talk to you about first, and some of you may be familiar with these concepts, and so it may very well be providing you with an overview. But the main piece of legislation in Ontario is the Ontario Human Rights Code, and there are various there's various equivalent human rights legislation across the various provinces. And for employees who may work for organizations that are federally regulated, like for example the railway or in the airline industry, the Canada Labour Code has similar types of provisions providing individuals with the right to be free from discrimination or harassment with respect to services, occupancy, meaning places to live, and employment. And so since I'm an employment law lawyer, I'm going to be focusing on the right to be free from discrimination and harassment in employment. And so as you'll see on this slide, the code provides individuals with the right to be free with respect to services. With respect to employment, you'll see there's a variety of enumerated grounds under the code, one of them being, of course, disability. And so individuals have the right not only to be free from discrimination and equal treatment with respect to disability in employment matters, but also free from harassment in the workplace. And so the problem that we often see is that equal treatment is not necessarily the answer for people who face challenges. And so the question is, how does human rights legislation deal with that situation? And many of you will be familiar with this, or some of you may not be familiar with it, but the duty to accommodate. And under human rights legislation, and this is the same across Canada, an employer has an obligation to accommodate an individual's disability, and that may, for example, include modifying various aspects of the job, modifying the timing of certain tasks, modifying the work and expectations associated with the job. And at the end of the day, it's a really important obligation that employers have to follow, and they have to be able to establish and prove that they've engaged in this duty to accommodate. In order to accommodate an individual's disability, an individual's condition has to be considered a disability within the meaning of the code. You will see I've excerpted what the definition under the Ontario Human Rights Code is for a disability, and you will see that it expressly includes in subparagraph A a brain injury. And you'll also see various other parts of the definition that may be applicable to certain individuals. And so I've underlined those for convenience. The duty to accommodate has to be considered in all aspects of an employment, and it will apply, for example, if an individual is looking for work, or if you're already employed by an employer. It will apply when considering what an employee can do and whether they can perform the certain functions of their job or another job. And so, for example, it may require an employer to accommodate physical limitations. And that might involve, for example, consideration of whether the employer can install ramps or handrails, or provide reserved parking spaces for employees. If there are visual problems or limitations or restrictions, an employer will have to look at whether, for example, changing the lighting from fluorescent lights to high intensity lights or white lights might be something that could accommodate an employee, or providing glare resistant screens on computer monitors. If there are issues with, for example, employees that are not able to work for the entire day for a regular 8-hour shift or 10-hour shift or 12-hour shift, depending on what the normal or regular shift is, the employer will need to look at reducing hours of work, permitting flexible scheduling, allowing for longer or more frequent work breaks, providing additional time to learn new responsibilities, air-free learning. I've had a number of cases where individuals with brain injuries have required air-free learning to be accommodated in the workplace, which is essentially having a one-on-one coach, so the employee and the individual learns how to do the job without making a mistake, and so that they learn how to do the task or the function right on the first occasion. If there are concentration issues an employee brings forward, an employee may be placed in an area that is a low traffic work area, away from others, reducing distractions in the work area, avoiding assigning that individual a multitude of tasks. If there are memory issues, an employee may be permitted to tape record meetings or be provided with typewritten minutes of each meeting. They may be able to insist upon having instructions provided in writing versus verbally. They may be given job aids or instructions close to frequently used equipment, or where tasks can be reduced to instructions. Those type of job aids may be required. And so all of these types of accommodations that I've listed are things that I've actually had to deal with and advise employers on when employees have come forward requiring their job to be accommodated. The duty to accommodate applies when considering whether an individual can attend work. And so for attendance issues, and the reality is an employer is going to be held responsible for having to consider whether flexible leave and flexible hours and reduced work hours are possible for that employee. May not be ideal for that employee. The employer may not want to do that, but the legal obligation is that they have to engage in those considerations.
Sorry, Tom, it's
Yes.
Carrie. There's a box that's appearing over your slides on our end, a small box. So
yeah, it is applying on my, it's occurring on my end too.
Okay, I wasn't sure if it's triggered by something on your end. Someone's trying to get a hold of you or something.
No, I'm actually not on. I'm not online. It said, please move this window away from the shared application.
Yeah, are you able to move it? We can't move it on our side, so I'm assuming it comes from yours.
From the share. Again, this I don't. How do you? Are you aware of how I would move this window?
Just click and drag it.
Yeah.
No.
It's.
Okay, Heather, do you have suggestions?
Sorry,
Oh. No, it fades in and out.
Yeah,
okay,
well, I'm seeing it right now.
Yeah, that's fine. Yeah, I just thought if there was an easy fix.
Yeah, no, and I wish if I, while I can speak on the law, I must admit I'm very challenged on IT issues.
No problem.
Okay, no problem at all.
Sorry about that. I can tell you it's certainly not a part of my slides. So
can you click on it, and does it show anything when you click on it?
When I click on it, the slide moves.
Okay, so it's behind your. That's weird.
That's okay. I think we'll just the slides will come out as a blanket. You'll be able to see the slides perfectly okay when we share them on the website. So.
I'm sorry about this. I would.
That's okay. Don't worry about it, Tom. We don't want to take up
No,
your
it's
time.
okay. I mean, I appreciate it's distracting, but I can see it fading in and out as well. So the obligation to accommodate on the part of an employer is triggered when an employee requests accommodation, or when the employer reasonably becomes aware that an employee requires accommodation. And so the key message here is to ensure that your employer or your prospective employer is aware of any restrictions or limitations that you have. There's lots of case law that establishes that an employer is not required to accommodate restrictions or limitations that the employer was reasonably not aware of. And so to the extent that an employee does need to be accommodated in some aspect of their job, they really do need to bring that forward or have a caregiver present that information to the employer, so that the employer won't be in a position where it can state that it had no idea that accommodations were necessary. If an employee is unable to perform the essential duties of a job, an employer will not necessarily have to accommodate an employee in that job. And so essential duties are what we often refer to as core duties and responsibilities. If an employee cannot perform the core duties and responsibilities of a job, or the essential duties, an employer may not be able to accommodate that individual. But the two key points. The first key point is that an employer has to truly engage in an analysis of whether the job can be modified or amended to see if accommodation is possible, and whether certain duties or responsibilities can be taken away from that employee or modified in many ways, as we just talked about a couple slides ago. The second key point is that an employer, if they cannot accommodate an employee in the existing job, that they have a legal obligation to look for accommodation in other jobs in the organization. So, for example, the employee may not be able to perform the core duties and responsibilities of their former job or their current job, but it may very well be possible to perform another job in the organization. And so that situation arises quite frequently in employment law, and I've had numerous cases where that has in fact been required and has been done with success. Medical information. I wanted to talk, are there any questions anybody has so far, or? Okay, I'll just go on, but if anybody wants to have any, ask any questions, please feel free. Medical information, because of the legal obligations that are put on an employer with respect to the duty to accommodate, the employer is permitted to take reasonable steps to verify whether an individual's stated needs or requirements are actually supported medically. And so this involves the delicate balancing between an employer's right to access medical information versus an employee's right to privacy. And you'll see that there's this chart that I've prepared. You'll see that the request for medical information often arises in three circumstances. The first is for a medical absence, and that's where an employee has gone off on a medical leave, and in order to justify or support the absence from the workplace, the employer will be entitled to request information sufficient to explain the absences. And so just to be clear, that sufficient medical information is reasonable medical information, not an entire medical history, not an entire history of personal information, not an entire medical history of a number of conditions or ailments that are relevant to the absence or are relevant to the accommodation requests. The employer will often ask for medical information in the return to work scenario. And in certain cases, if the illness was brief or the absence was brief and the individual's recovered and they're clear to return to work, the information may not, there may not be much information there at all. Whereas if it's a complex situation, for example, with an individual that suffered a traumatic brain injury, and an employee has significant disabling conditions or restrictions, an employer in that circumstance will need to ensure that that employee is returned to work safely without posing any health risks on that employee. And so because the law does require an employer to take every reasonable precaution necessary for the safety of a worker, in order to fulfill that obligation, the employer needs to be sure that when an employee is being returned to work, that employee is actually able to perform the duties and responsibilities that they indicate that they believe they can. Because sometimes employees believe they can do something or want to push themselves because they want to come into the workplace, even though a doctor may not necessarily agree that it's a good idea or supported medically. And then the final context an employer will look for medical information is in the context of accommodation. And here the law recognizes that employer does have the right to seek information to determine what actually is a restriction or limitation supported by the medical evidence. Again, to be very clear, it is reasonable information. It is not boundless, it is not limitless, and there's a number of employers where an employer may try to seek medical information that is quite frankly too broad and irrelevant to the restrictions and limitations that an employee is presented. And so in those circumstances, you need to be aware that you do have a right not to provide medical information that is not relevant to the employer's ability to assess whether an accommodation is possible. So it is ultimately, at the end of the day, a balancing exercise between the employee's right to privacy and an employer's right to manage the workplace. Can an employer ask about the following? Depending on the circumstances, for example, if it's an accommodation situation or it is a situation where it's a return to work, employers historically and traditionally are going to be entitled to know that an employee is receiving treatment, not necessarily the details of the treatment, but that they are receiving treatment from a licensed physician or a specialist that has experience or the education to deal with a particular type of situation. But they're not necessarily going to be entitled to all the details of a treatment plan and the medication that might be prescribed and those types of things. Again, on a case-by-case basis, you'll want to consult with your union. If you're a unionized employee, you may want to consult with counsel if you have any concerns in that regard. But generally speaking, there are limitations. Prognosis, in other words, how long the restrictions and limitations may be in place for, an employer will generally be entitled to that information. Diagnosis, in other words, what is the medical condition? Employers generally will not be entitled to know what the diagnosis is. Employers are entitled to know what restrictions and limitations are of a condition, but not necessarily what a diagnosis is. There are certain limitations to that, but the general rule, employers should not be asking you what your medical condition is. And this is not just with respect to disabilities associated with brain injuries. This is associated with any medical conditions. The last piece of legislation I wanted to talk about is the Accessibility for Ontarians with Disabilities Act, or what we commonly refer to it as the AODA. And the AODA was put in place a few years ago, and it works in conjunction with the Ontario Human Rights Code in many respects, because a lot of the obligations placed on employers through the AODA, quite frankly, the law around the Human Rights Code has developed so as to require employers to do a number of things that the AODA requires employers to do. And I've listed them on this slide and the next slide. So, for example, there's a regulation that is part of the AODA, the Integrated Accessibility Standards. And you'll see that, for example, employers through the recruitment process have to notify employees about the availability for accommodation. During a recruitment process, an employer has to notify job applicants that accommodations are available upon request in relation to materials or processes to be used. So that may involve, for example, an employee may need more time to take a test. An employee may need to have instructions not communicated verbally, but have a written instruction sheet. An employee, a prospective employee, may need to a quiet environment and may need to take a test instead of in a classroom setting, may need to be segregated and work in a quieter setting. Those are all reasonable forms of accommodation that an employee may very well be requested and that a prospective employer would have to grant. If an applicant requests an accommodation, the employer needs to work with the applicant and explore what suitable accommodations are. Employers, when making offers of employment, have to notify the successful applicant of its policies for accommodating employees with disabilities, which naturally every employer needs to have those policies in place. When an employee with a disability requests it, employers have to consult with the employee to arrange for the provision of formats and communication supports for information needed in order to perform the employee's job. And as we've talked about before, those types of things may, for example, be longer time to complete tasks. It may be requiring job aids. It may be allowing individuals to record meetings. It may be, if there's visual issues, it may very well be, things may be printed in bigger fonts. Variety of straightforward accommodations that employers should have not much difficulty in implementing. Employers have to have in place plans for the development of documented individual accommodation plans. You'll see the second bullet from the bottom on this slide, employers other than employers that are small organizations. A small organization is defined in the AODA as an organization that has 50 or less employees. And so for larger employers, they will always have this obligation. For smaller employees, they don't have this obligation under the AODA, but it's important to note that they're under the Ontario Human Rights Code. If an individual needs accommodation, it doesn't matter if they have less than 50 or more employees. And the reality is, I would be advising that employer that they would have to develop an accommodation plan with an individual. And so simply because this part of the AODA might not apply to a smaller employer, it doesn't mean that an employer does not have the obligation to develop an accommodation plan for an employee. To recap, I think it's really important that everybody knows, both caregivers and individuals who've experienced brain injuries, that there are a lot of legal requirements that have been placed on employers to accommodate employees and prospective employees in the workplace. And if I can say one thing, and from my experience, is that if an individual, if you do have any restrictions or limitations make sure your employer knows. Don't give an employer the ability to say that I truly was not aware that an individual had any restrictions or limitations. And because once they are aware of what those restrictions or limitations are, their obligations to accommodate kick in.